regard to count one, premeditation, I think coupled with the physical evidence of the way the child was wrapped and placed in the trash can, you couple that with the voluminous amount of evidence where the defendant was giving different stories as to where the child was, as to how the child was doing. When you look at that count in light of the statements the defendant was making on social media, the fact that there seemed to be, from the proof, there seemed to be a cutoff date where before that date, the defendant seemed to be very caring for the child, and after that date, it was story after story about where the child was. The defendant appeared to have moved on to other things. And I think when you take all that evidence, and a lot most favorable to the state, that the jury would be able to find premeditation. As for the cause of death, both medical examiners stated that in their professional expert opinion, the cause of death was asphyxiation. Again, Mr. Scott did a good job cross-examining those witnesses to introduce other potential theories. But courts of the opinion the state, when looking at that proof in light most favorable to the state, that they have put forth evidence that the jury can consider. So with regard to count one, I want to deny the motion for judgment of acquittal. With regard to counts 2 and 3, the abuse or the neglect, I think that taken in light most favorable to the state, the fact that that child was wrapped and placed in the garbage can, I think the jury can look at that, and I think that those facts taken along with all the other proof in the case. There was testimony that the child was filthy dirty toward the time late November, early December. I know that the one babysitter testified how dirty the child was. We saw pictures of the living condition of that trailer when the gentleman was cleaning it out. And I think that taking all that together, the jury would be warranted in finding abuse or neglect. I think that taking the light most favorable to the state, that those two counts would survive the Rule 29 motion. And I'm going to deny the motion with regard to those two counts as well. With regard to the tampering with evidence and false report charges, as well as the abuse of the courts and failure to report, when the court looks at all the statements, all the messages, all the social media posts, when you take those as a whole and view them in a light most favorable to the state, I think those are issues the jury can determine and will have to determine. I'm going to deny the motion with regard to all counts for those reasons. Mr. Scott, first question that I have for you is, will the defendant testify?
Judge, we're prepared to state at this time the defendant will not be testifying.
All right. In that case, we have to go through the Moman versus State questioning, and I'm gonna hand this down and let you do that.
Judge, for the purposes of the record, would you like her to come to the,
No, just put the microphone back up on the table for that. We just need to make sure she's recorded. Ms. Boswell, raise your right hand. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, ma'am?
Yes, sir.
Go ahead, Mr. Scott.
Megan, I want to ask you some questions about my representation of you and explaining to you your right to testify.
Okay.
I've been representing you for a couple of years now. We've met and discussed your case. You need to answer out loud.
Yes.
Okay. And part of that, I've talked to you about you have the right to testify, is that right?
Yes.
And if the jury can't hold it against you if you don't testify, do you understand that?
Yes.
Do you understand you have a right not to testify?
Yes.
Okay. And if you decided you wanted to testify, I couldn't stop you from that. Judge Goodwin couldn't stop you. Mr. Harper couldn't. That's solely your decision. You understand that?
Yes.
And after consulting with me and looking at the evidence and hearing the proof here in court, have you made a decision as whether or not you want to testify?
Yes, I have.
Do you want to testify?
No.
I think I covered it, Judge. Approach.
Yeah. All right. Will you have other proof?
No.
No? I know it seems like a calisthenics exercise, but we need to bring the jury in. I need to ask you that question in front of the jury, and then you can rest. And then I gotta send the jury out so we can finalize the charge and give the parties time, because what we'll do, as soon as the proof closes, we'll take a break, and it'll be an extended break. We'll take a break so that I can get the charge finalized, and then what I do is I will make a notebook for each juror so that they can read and follow along as I read the charge to them. It's been my experience, especially after lunch, that fewer of them nod off if they're reading with me. Plus, it gives them the charge when they go back in to deliberate. Each one of them has a copy of the charge so they can actually look at it and refer to it. And that also will give you time, because what I'll do is once the charge is done and I get the notebooks ready, we will bring them back and I will read the charge to the jury